All right, let's proceed to Nnamdi Kanu's case, which is one of the hottest issues in town. Justice James Omotosho of the Federal High Court in Abuja has given Nnamdi Kanu, the leader of the indigenous people of Biafra, a deadline until November 5, 2025 to open his defense against terrorism charges against him. The court warned that if Kanu fails to begin his defense on that date, he will be deemed to have waived this right to do so, and the trial will proceed without it. This development comes after several adjournments during which Kanu, representing himself without legal counsel, has refused to enter a defense, insisting that there is no valid charge against him. The prosecution has closed its case, having called 5 witnesses, including operatives from the Department of State Services. Now, earlier in the trial, Kanu had filed a motion and affidavit instead of a final address as directed by the court, further delaying proceedings. The trial judge, however, acknowledged Kanu's lack of legal expertise, allowed him time to seek proper legal guidance. Now, this marks a critical juncture in a high-profile and long-running case that dates back to 2015 concerning charges related to terrorism, and separatist agitation led by Kanu. The court has scheduled the next proceedings on November 5, setting the stage for Kanu's defense of further legal consequences for waiving this right. You're watching What's Trending on DDM TV. For more insights into this story, do not hesitate to hit the like button, make your comments on this, and subscribe to DDM TV. Also, share my video so that you will get updates and insights more. I'm Tosh Raphael. Have a nice day.
First, we understand that you are no longer in Kanu's legal field.
No. So, we remain as consultants to him, okay, and as his brothers, okay, and braves in counsel.
Okay, based on today's proceedings, what did you observe and what is the way forward?
Well, my observation is that let's keep in mind that 14th October this year made it 10 years that this case has been pending. That the matter has become too complicated for the judiciary to handle underscores our core point, that this matter is more political than legal. That this is a matter for the executive branch to settle with a political sleight of hand. It's not a matter to be offered to the limited wiggle room of a court of law, of the judiciary. There is a lot of wide bat, a lot of wide space left for politicians or political leaders of this country to resolve political issues that border on agitation. Why this one has become intractable is very, very, very disappointing. There's a thesis that has become intractable because Nnamdi Kanu is an Igbo man. That thesis is becoming more and more valid by the day. So what is playing out in court now is nothing but the best evidence that this matter has gone beyond the province of judiciary and should be taken back, by the executive branch that started it anyway. There is no trial without prosecution. So it's the executive branch, the president, that triggered this through the office of the Attorney General. So the president can direct the Attorney General to take the case back to the table to see whether it should be resolved politically. But to try to resolve this case before the courts is becoming more and more impossible every day.
Is this a call for political intervention on this case?
Well, of course, everybody is calling for that. It's not throwing in the towel. What is wrong with calling with reconciliation when the courts of the land actually recognize it as well? Check out Section 17 of Federal High Court Act. It called on judges to seek reconciliation between litigants before them, including criminal cases. Section 174 of the Constitution empowered the Attorney General of the Federation to discontinue criminal prosecutions. So why should anybody say this matter should be resolved in courts when we have an alternative route of resolving it politically that appears to be easier and that would appear to be pleasing to everybody?
Okay, let's talk about the proceedings today.
The procedure today?
The proceedings today.
Okay.
What next?
I will yield to one of my colleagues to discuss that.
It's good for us to put the record straight. Nnamdi Kanu is not saying that he will not enter defense. Nnamdi Kanu said, under what law are you charging me? Going by the constitution, there is no charge against him. that tell me the law, that the court should tell him the law upon which he's been tried. Now, my lord is on his own saying that whatever thing that you have to say should be ruled at the final written address, and it should be upon a conviction to know whether you are supposed to be convicted or not. And Nnamdi Kanu said no. There are thresholds, there are hurdles upon which you need to cross for you to reach at that particular issue. And one fundamental issue there is that my lord said, we are talking about issue of extraordinary rendition, the way you have been brought back from Kenya to Nigeria. And he wants somebody to come and give evidence on that. There is nothing before him. And if you watch the motion Nnamdi Kanu filed, Nnamdi Kanu said, Federal High Court has given a judgment in respect of that, and also awarded 500 million naira against federal government in his favor. That judgment is in the court file. Court of Appeal, in their judgment, also gave ruling on that and made comment about that. CTC of that judgment is in the court file. Supreme Court, in their judgment, also took judicial notice of that and they condemned that attitude. They are all in court file. There was a motion challenging the decision of the court where these issues are being raised, and Nnamdi Kanu made reference of the motion in the court file. Yes. And under the Evidence Act, Nnamdi Kanu is saying that under the law, court is obliged, is under obligation to take judicial notice of every document in your file. Yes. So asking him now to go and enter into a defense and start giving evidence on that is a waste of time. Yes. That court is on its own supposed to take so moto raise this issue. Yeah. Court is expected to raise this issue. Now there is a charge before me. Please, under what law? Address me on this issue before I go into trial. And Nnamdi Kanu filed the motion, and I think that motion, Nnamdi Kanu said that motion should be heard, and all this issue I raised should be trashed for me to go into trial. So, and into defense. So my lord, Nnamdi Kanu maintain his position on that. So my lord said that he has joined to tomorrow for him to enter defense. Just like we said, we are no longer into the matter, but we are still he's still consulting us. I am saying so. On handling his matter in court, he felt that he's competent to do that. So whatever advice he needs from us as his lawyer, we should also offer the legal advice, just to get the record straight, so that people will not say that Nnamdi Kanu refused to enter defense. No, there is no such issue. Nnamdi Kanu said, address me on this issue. Okay. That is the position.
The honorable member here.
My name is Right Honorable Obi Akocha. I represent the great people of Ikuano, Omaya North and Omaya South Federal Constituency of Abia State. I represent Mazi Nnamdi Kanu. From what I saw today in court, there seems to be a systemic effort being put in place to steamroll and railroad Mazi Nnamdi Kanu into putting up a defense and leading to conviction. There are procedural issues that must be heard before the matter can go forward. And I think that is the motion that must be heard, hopefully by tomorrow. Nnamdi Kanu still remains a prisoner of conscience. He's been detained unlawfully. And we are also using this medium to continually call on Mr. President to invoke Section 174 of the Constitution of the Federal Republic of Nigeria as amended for the Attorney General to enter another prosecute, at least before the determination of the court. We are very optimistic that Mr. President, that we know is a listening and attentive president, and that he will do the right thing in the shortest possible time. Thank you.
Okay. My colleague here would like to...
Okay, thank you very much. Yeah, thank you very much. Well, as an ordinary citizen, as I'm not speaking now as a lawyer, as an ordinary citizen, if I am brought before a court of law, I should know the law that I have contravened.
Yes.
You cannot ask me to enter a defense for a law that does not exist, and particularly the law that the Supreme Court itself has declared non-existent. To what will I be defending? We're in a country where our laws are written. This is not England, where you have an unwritten constitution or unwritten law. We have a country where all our laws are in black and white. This is a lawmaker here. Mm-hmm. They made the law we're talking about. Mm-hmm. And if you ask him, he will tell you that there is nowhere they made chapter 45 of the criminal code. They didn't make it. Honorable, did you people make that law? It is not in existence. So who made that law? Who made that law? Was that law made by the Attorney General's office? And the Attorney General does not have the powers to make laws. So I am saying, as an ordinary citizen, that Nnamdi Kanu is completely right and within Section 36 of the Constitution, which borders on his fundamental right to fair hearing, to be charged with in a court with a law that is in existence, not with a law that is not existing.
Wonderful.
Thank you.
Thank you very much.
As you can see, the way I addressed Nnamdi Kanu for the purpose of this trial is representing himself in this matter. So, and on this particular issue, we are now acting as his consultants. I'm not the only one. He has many consultants, both foreign and local, whom he consults on this particular issue, not representing him here. Now, if you recall, Nnamdi Kanu has, to tell you that he's ready for his defense, has listed the witnesses he intends to call in this particular matter. So, in the course of consulting, he discovered that the law upon which he's been charged and tried does not exist. So, ordinarily, the court is expected to to raise this issue and ask the parties to address him on this issue, whether the law does exist. So now Nnamdi Kanu has raised the issue and said that I cannot enter defense because in a criminal jurisprudence we have a procedure. The procedure is that for you to even assume jurisdiction, there must be a law. For the law to even exist, for you to rely on that law, the law must be an existing law. And Nnamdi Kanu now on his own filed a motion on this particular issue, telling my lord that the law upon which I'm being tried does not exist, in line with Section 36 sub 12 of the Constitution. But my lord on his own, just like what we said, my lord on his own said that section is talking about conviction. And Nnamdi Kanu said no, you can't be talking about conviction without trial. The trial will lead to conviction. So for you to even talk about conviction, you must first of all address all those issues that will lead to conviction. So that is why we are here. It's not as if that you don't want to enter defense, but he's saying, tell me the law upon which I'm being charged and tried.
But why are we here at this stage, knowing that at the point he once pleaded not guilty, and then the witnesses from the prosecution were examined and cross-examined?
If you say that you are not taking plea, then how will you tell the judge to discharge and acquit you for no trial? Because you first of all plead guilt. Are you saying you first of all plead guilt for court to have jurisdiction for you to even make an application? If you do not plead guilty, there is nothing before the court. So that was the issue. And he's now saying that if the law, the charges upon which I pleaded guilty, does not exist. We are talking about law.
Yeah, what about the trial? There was a trial.
The defense opening their case.
The prosecution.
You can raise it. The law said that you can raise all this issue at any stage.
Okay.
Before judgment, you can raise it at any stage, either before prosecution open his case, upon prosecution closing his case, or at any stage. So that's the stage Nnamdi Kanu is. So on our own, so we believe that the court will first of all hear this particular motion. I hear them saying, but just like the court said, the court has every right to take decision one way or the other. Then Nnamdi Kanu still have opportunity of going on appeal.
Thank you very much.
It's my pleasure. I know, sir, now you go there.